problem in animal law to have people in law enforcement or with DAs or prosecutors that they don't sometimes take it as seriously as we would hope they would. USDA inspectors, you can work on the inside. A lot of federal statutes that we'll get into later, they're enforced by the USDA. And so it's great to have people that are kind of have animal-friendly bent to them in those roles in terms of the Animal Welfare Act, Humane Slaughter Act, research, circuses, anything that deals with animals. It's actually a good role to have animal-friendly people there, and authors, philosophers, it's just a wide range of different professions that can intersect. So there are kind of some basic different areas of legal practice, and these are actually laid out pretty well in the overview of the law. And so I was going to go through some major tracks. There are criminal law and civil law are kind of two major practices. And so criminal law is, you can kind of know like murder, burglary, those sorts of things that are on behalf of the state. So, and they prosecute the crime, so it's not in between two individuals, but it's prosecuted either by a district attorney or a city prosecutor, depending on the different level of where the crime was committed. And this is where you kind of see the courtroom dramas, and that's really not what the law is about, actually. It's not quite so cut and dry, in 30 minutes you don't get, the big conclusion. But this is kind of, when you see your courtroom dramas, it's all about, beyond a reasonable doubt. And then, so people that are in criminal law, prosecutors, public defenders, private attorneys, and a lot, defending activists is also in there too as well. So there's definitely a way for you to be involved with the law on the criminal side. The prosecutors and judges and media, they need to know that this is important to you. And it's great to call them. You hear about something horrible that happens to you or whatever. They're actually open to hearing from you and hearing your opinion about what they should do about it. And it can be a really kind of, if they have a lot of pressure to try to not be bargain or sentence them longer, it's a great role that you can play to have more prosecution. This is an amazing website, www.petabuse.com. It's a great database of different things going on. It tells you ways to get involved. And you can actually look and see, if your neighbor is or convicted of animal cruelty. It's a good resource. Civil law. This is kind of where the vast majority of animal law developments are taking place. And if you hear of somebody saying that they're an animal law attorney or they're practicing an animal law practice, this is most likely what they're doing. And this is a lawsuit between two parties. So the government isn't involved. Somebody hires an attorney and to bring a case on their behalf. And in most cases, it is a companion animal. And these are based on statutes and common law, so it's also, there are laws that civil law attorneys depend on to be able to bring cases forward. But it's also, this is where a lot of judge-made law is, and this is where a lot of advances are made, because if you look at, 100 years of this is how we've treated animals and, non-economic damages or things like that you'll hear, animals as property, judges can be, they can change the laws. They can be brave and kind of push forward and realize that how society views animals is much different than how the law treats them. So this is where some really exciting things are happening in the law. This one is the standard is lower. Preponderance of evidence, it's more 51 to 49. So that's why kind of the classic example is the OJ trial, where he wasn't convicted criminally, but he was found liable civilly because the burden of proof is different. And then, so in the criminal law realm, back to that world, if you're found guilty of a crime, you're paying a fine to the government or you're going to jail. In civil law, it's a recovery of damages or to try to get some sort of, to stop somebody from doing something. So in the veterinary malpractice realm, you would think like, okay, your animal got hurt. Damages that you can get are either the cost of your dog, economic damages, and that's kind of a struggle too of what is this dog worth in economic or cat worth in economic terms. A lot of states say market value. There are a lot of different states, including Oregon, that you can try to recover special value, so that it's up to the attorney to say, yeah, you can get a black lab for $100, but this particular black lab is worth much more to this family. So that's the damages. And then in terms of injunction or equity, kind of an example that something that we work with a lot is nuisance laws. In terms of people having, like you live next door to a hoarder, and they have 100 animals. How do you, kind of use the law and nuisance laws in creative ways to make sure we don't have. And animals are property. It's a little bit of a benefit, and as you know, it's kind of something that people are struggling to kind of change that classification. And I think the law is slowly but surely recognizing that although animals are property, they can be treated differently than a couch or a car or whatever else. Some laws don't really recognize that they're living sentient beings, and I won't tell you too many war stories, but the recent case I had with a veterinary malpractice case asking for non-economic damages, went into the courtroom and the judge said, taking your dog to the veterinarian is like taking your keys to the care person. And, it's take it in, they fix it or they don't, and, you just get a new one. And so that's kind of the paradigm that we're working within, but to try to let them know that, yeah, you can have an owner and you can have those protections, because actually if animals weren't owned, you wouldn't have standing to bring a veterinary malpractice case, because you're not really representing the animal. You're representing the owner of the animal who's hurt. So, there is ways to actually benefit animals and advance animals. But judges really need to be, and the laws need to better reflect that it's a much different situation, because your TV is broken. You look at how much would I pay to fix it, and and you look at just mostly the economics of it. You might have a little bit of attachment to it, but it's very different than how you would an animal. And people spend $20,000 on hip surgery or kidney dialysis or those sorts of things. It's not a rational economic decision that people make. It's based more on their love and affection and relationship with the animal, rather than in this cost-benefit relationship or this cost-benefit analysis in favor. So, okay. So, civil practice. These are kind of personal injury and tort. Sometimes it's kind of a very, very traditional and kind of very common area of practice for animal law attorneys. And these are just some examples of some different cases and different theories that animal law attorneys are pursuing. There's also contract law. Obviously, as owners, there's contracts in terms of breeders or shipping or any sort of anything that kind of involves animals. Puppy lemon laws are another kind of advancement. If you think of lemon laws in terms of cars, if you buy a car and you have a guarantee that it's some certain condition, and you get home and it's not that condition, you can take your car back or get your money back. Some states have these lemon laws, but they don't work that well for puppies, because you come home and you fall in love with it within 5 minutes, and you don't want to get another puppy. So it's kind of one of those instances where things are advancing in terms of recognizing that people need to have, breeders need to be held to a higher standard, but it's an area where the law doesn't necessarily treat animals the way it should. And then insurance. Insurance comes up a lot in, what's a tort? Okay. That's a very good question. That is the area of law. It's mostly referred to as personal injury. You kind of think of car crashes, anything like that. And it's it kind of goes through in the civil law as well. There's negligence, just kind of being careless. So, you're driving down the road and you have your coffee and your cell phone and all those things. And so, and all of a sudden, a kid runs out in front of you, and then so that would be a tort in terms of your act to them being careless. Or, a kid runs across the street and you ram into them. That's intentional, So, but it's just there's contracts, like how your relationship with people, and then there's torts in the harms that go on between relationships with people. So I don't know if that answers your question. Or Jordy, you want to jump in? Yeah, it's really about the relationships between people, and it's kind of the carelessness for the harm that you cause them. Does that make sense? There is, in that there are civil trials and criminal trials. So in the civil sense, you're still going through the same, the steps of a trial, and if you just look at like Multnomah County in Portland, you sue under a certain amount, you go into arbitration, and there's different steps to go through, which means you don't go to trial because it's such a low amount of money, but you try to work it out in a different setting. But it's still, you file a complaint and you kind of lay out all the things that you think that person did to harm you. And then you have damages, either monetary or you want to ask them to stop or to do something. But it's not based on something of, here, I wrote out this contract, like you were supposed to sell me, this car, and you didn't do it, and so they'd be based on that agreement that you have that's written out. This is more just because society has these, rules set out in terms of how you're supposed to behave, and if you're not meeting those behaviors. So then that kind of goes between the two. Landlord-tenant issues, the American with Disabilities Act comes up a lot in this as well, in terms of, and just the ADA in general, in terms of access of service animals, where they can go, what they can do, and landlord-tenant issues. You hear a lot of that with, like renters agreements or condominiums. Who's able to have pets at what point, and can they change those rules? And what if you have, weight restrictions and all those sorts of things. Animal law attorneys get involved in restrictions. Estate planners, there's a lot of stuff happening with pet trusts, so now people can care for their animal, make sure that their animals are cared for after they die. And it was hard in the past with animals as being property. You normally can't leave property for property. You can't leave money for your property. But there are now some exemptions on the federal and different state levels that allow you to do that. So there are some estate planners that it's kind of a very traditional area of law where we can see with both estate planning and family law, we have people that just do traditional area of law but then have pet or animal issues in their practice, but they're not like just pet trust attorneys. That is a good thing. And then obviously family law, custody issues. There are a lot of different ownership disputes between companion animals, and that's another area that judges weren't very happy to see in their courtrooms, and some still aren't. Most family law judges are now allowing people to deal, they can decide if you want to have Fluffy every other week or every other month, and you guys can privately decide to do that. But if you breach that agreement, they don't want to get involved. But it's interesting to hear from family law attorneys that a lot of times that's the crux in a divorce is what happens to the family pet. So it's a really important issue that I think family law practitioners and judges are really going to have to just really start considering. Okay, so like I said, there's some very traditional areas of law that animal law is based on. One of those is the Constitution, and these come up in terms of, and you kind of hear about police shootings, Adam's talking about that a little bit next door, and you can kind of look at his materials in here as well. It's kind of a sad story you hear in the news every once in a while about these shooting dogs. Free speech comes up a lot with hunter harassment, protests, civil rights. It's kind of a very interesting area of law as well. Kind of hear about these civil rights issues in terms of people in prison who they don't want to eat the government or whatever prison issued food, and is that do they have a right to say that this is part of their religion or part of those sorts of is that part of their civil rights to be able to ask for different things. And hunter harassment, there are actually some laws that say that if you're out in the woods with a hunter, you cannot, like wave your arms, jump around, blow your horn. You're interfering with hunters. Right? And so that's actually an area that animal lawyers work on as well. And standing is always an issue. Standing is if you have the ability to bring a lawsuit. Either you're harmed, and it really is if you're harmed. And there are laws such as the Animal Welfare Act or Humane Slaughter Act that don't allow citizens to sue lawsuits. So you can know that you can see a violation of the Humane Slaughter Act and say you didn't render this animal unconscious and free it from pain before you slaughtered it. But just because you saw it and you don't like that it happened, you don't have the ability to bring a lawsuit to try to enforce it. And animals don't have standing in the court either. So, you can't say, well, as a lawyer, I'm representing this cow that was inhumanely slaughtered. And so that is actually very interesting, and it comes a lot within discussing your theory and why do people, why have we classified animals as property and separate from, we have this big wall between the animal world and from us. And, but if they're living beings, why can't they have their interests represented? And an argument for that is to have a guardian ad litem, particularly for children. Children aren't able to represent themselves, but we designate someone to represent their interests in court. And it's something that animal law attorneys are working on as well. So a really big intersection between animal law and environmental law comes in these environmental statutes. Some of them are written, especially Clean Water Act, Clean Air Act. They're not necessarily to protect animals, but they certainly derive some benefit from them. And it kind of a big difference between environmental law and animal laws. With environmental law, there's much more of a focus on the species as a whole. And animal law really looks at the animals as an individual. And so, through all of these, they kind of look at, under NEPA, the government has to do an environmental impact statement and see, what the harms would be. If we cut down 100 trees, what would it do to the water? How many animals would it kill? All those things. And it's not like we shouldn't kill the animals. It's, if we have 10 that are killed, what will it do to the population? Where, an animal law perspective would much more be, well, you shouldn't kill one. And it comes up a lot in international issues as well. If you think of like elephants in Africa, there's arguments that, well, if we allow them to poach these elephants for their ivory, they are now an economic commodity, so therefore people want to save them. And so, is that okay? Is it okay to sacrifice, 10 elephants a year to be poached for their ivory, thinking that, well, that will mean that 100 more will be saved because we want to keep them around? I obviously don't do that analysis, but it's an interesting obstacle for animal law attorneys to deal with, especially in the environmental context of how do we balance, the no killing of life with the reality of what's going on in the world and animals being treated as economic commodities. Administrative law. This is government agencies kind of fall under administrative law. So anytime there's any sort of agency action, that is what's going on. You have the USDA or Food and Drug Administration. Those are, or the FCC. Those are federal agencies, and they actually propose rules and regulations, and they're available on that website. And you can do searches for certain things. You can put in certain keywords, and like the USDA with the food pyramid or any sort of action they want to do, it's up there for comment, for public comment. So what a lot of law firms do, and animal groups such as the Fund for Animals or HSUS or Meyer and Glitzmachine, who's a great law firm, they'll go into these, and they'll comment on government action. And then if they are unhappy with what the government is doing, that creates standing for them to go forward to say, we commented, we had all of our, we let you know what we wanted you to do, and this is why we think you weren't doing it right, and therefore this is then. And another area of law that animal law attorneys deal with is kind of open government. There are state and federal Freedom of Information Acts, so FOIA, kind of the acronym for it, and it allows you to get an amazing amount of information from the government because they work for you. So therefore, you should have that information. Unfortunately, there are some exemptions. They like to black out everything that actually you want to see. So you'll ask for a letter, and kind of if you guys also Fahrenheit 9/11, you kind of saw that that was a FOIA request that they did, and then all the stuff about George Bush and past military action was blacked out, and that's the good stuff. But sometimes if they give you not the photocopy but the original copy, you can hold it up to the light and you can still read it. So sure, all the tips. And obviously, animal law isn't. There's not a really strong foundation without animal laws as the legislature. So in your materials, there's a little cute diagram about how a bill becomes a law, and I'm sure most of you learned this in high school through your government class. But what I hope all of you know is that you have an amazing ability to influence all of these steps. And it's a great way to have your voice heard. Again, your legislators, they represent you, and you need to let them know what your beliefs are and why you're voting for them, either because they are, really animal friendly, or you're not voting for them because they're not. And you can testify at hearings. Write to them, meet with them. There's this, if you write a letter to your legislator, they count that as, you're representing about 5,000 other people that aren't taking the time to write. So it's a great way to have your voice heard. And writing is a lot more effective than emails. And calling them and meeting with them is the most powerful thing that you can do. Because they recognize that you're taking time out of your life to drive down to your capital to meet with them. And they don't have a lot of people that come in. And so you'll really make a strong statement by actually going down there. And then if you have ballot initiatives in your state, like we do in Oregon, it's a great way to make sure that there are animal-friendly laws that are. Oh, sure. Yeah, it depends, and it is kind of, they can look at those at a little bit at the same level. And an email that has your own words is much more effective than, here's an internet petition that's going around and you just fill in your name, or if you just cut and paste. So they know, if they get 500 emails that all look the same, they're not going to be kind of given as much weight as if you wrote either a personal email or a phone call. They do. And I don't know exactly if it's the level of if a phone call equals an email. And I think each legislator does it a little bit differently. But I mean, it's kind of a little bit of the same sort of weight. And but it's, a meeting with your legislator is not going to be treated as a 1 mark as an email would. I'm sorry. Oh, torts in the glossary. Oh, good, yeah. So take a look through the glossary for very distinct definitions of different things. And hopefully that'll help you with that throughout the weekend too, as you sit in on some kind of heavier law panels. I'm hoping that this glossary of definitions can kind of help answer some of your questions. Humane Lines is it's a weekly email that you can get through. It's the Humane Society of the United States, Government Affairs Department, and Fund for Animals put this out every week, and it's great. It's just a little snippet of little things to do, super easy, lay it out for you, but it's a really effective way to be part of kind of the major things going on locally and nationally. And you can just go to hsus.org and go to Government Affairs or type in Humane Minds. So there are different levels of laws. They start out kind of on a local municipal level. So a good example of that is kind of animal control type issues of, does your dog bark too much? Are dogs at large? But they also kind of range beyond companion animal issues as well. State statutes, probably the most common one that you guys are familiar with is the animal anti-cruelty statutes, and that governs kind of abuse and neglect of animals. It's great in the sense that, of course, all animals should be free from abuse and neglect. It falls short for a number of reasons. They were originally passed really, again, to protect ownership interests and also to kind of preserve the moral fabric of our society, because it's not so much that it was hurting the animals as that it was hurting the people that were witnessing it. Interestingly enough, they really started more protecting livestock and farm animals almost exclusively. And then as it progressed, now all anti-cruelty statutes are really focused on companion animals, dogs and cats, which is a good thing because we all love them very much, but it exempts hunting, fishing, scientific research, slaughter, how you raise an animal, anything that people use animals for on any sort of economic level is exempted from the anti-cruelty statute. So, and again, it's great that animals are protected, have some protections, but just like if it's illegal to, bash in a dog's head, it's illegal to bash in somebody's windshield. You're not given the windshield rights, just like anti-cruelty statutes on animals' rights. It does protect them in some sense, but not probably as much. And again, prosecutors on the city, state, and federal level, they have it's called prosecutorial discretion. So they get to decide what they prosecute on behalf of the state. And so it's really up to those offices in terms of what their priorities are. So to have DAs and city prosecutors and whatever else to understand that animal cruelty is really important for the animals and people, there's a lot of evidence that to show the connection between the violence between animals and people, and they need to hear from you that it's important as well, because they're dealing with murder and drugs and rape and all those things that we also feel are really important to be prosecuted. The animals need to also kind of be part of the level of importance of the issue as well. And these are kind of the basic federal statutes that protect animals. The Animal Welfare Act is kind of the federal anti-cruelty statute. But again, it exempts a lot of behaviors. And both the Animal Welfare Act, and the Humane Methods of Slaughter Act, that really deals with how they're slaughtered. They should be rendered unconscious, but not how they're raised at all. And how they're raised is much more of a state issue, and those are common husbandry practices. Anything that's a common husbandry practice is pretty much exempt, but that is defined by the industry. So the industry says, we allow forced molting, we allow cutting off the beaks with hot wire with anesthesia, we allow 8 chickens in a wire cage this big, we castrate without anesthesia. I mean, all these things, they're common, so they're okay. And obviously they're not okay, but under the law, they're okay. And so that's a big thing that needs to change. And with the Humane Methods of Slaughter Act, it also it governs, mostly large livestock. It doesn't include poultry, which is a little over 90% of the animals that are slaughtered. So there's obviously a lot of gaps in the law and again, the wildlife laws. And there are issues with enforcement and funding. Both of these statutes are enforced by the USDA, who have some economic interest in making sure that there aren't more protections. And also they don't have a lot of people. And they govern, these are all the places where they're supposed to go. Federal research, breeders, circuses, roadside zoos. The list goes on and on and on of all the places that these people are supposed to regulate and enforce and to visit. And it includes zoos, SeaWorld, all of them. And they're a limited, handful of people in each state that are going around and making sure people are complying with these statutes. So that's another thing that's being worked on the federal level is to get more funding. That's all that I have to share. Here's my contact information at both the National Center for Animal Law, which is here at Lewis and Clark, and then I also practice law in Portland as well. But I see that I have questions, so I'll just no questions? Okay. So, I might have to get back to you on a more specific answer, but use to sell live animals? I'm going to have to get back to you on that, unless does somebody else know the answer to that. Where did you know? It depends on the context. If you are part of a nonprofit organization and or an individual that's concerned, you can certainly use animal lawyers as a resource. And we don't have a board experts law in our head to help you. So on any sort of issue that you're concerned with, we can help research the answer. On an individual level, it's really more of if you or your companion animal is harmed in any way, either from a neighbor, vet, somebody, the delivery truck runs down the street, and it is a lot easier for the law to advance for companion animals, but we got a phone call about fish, about a woman whose fish were killed by her ex-husband. And so fish are, they're included in an anti-cruelty statute. As a private attorney, we don't, the state would prosecute the cruelty aspect of the anti-cruelty statute, but as a lawyer, you can file a lawsuit to pursue that. What's hard is that sometimes it's not very practical economically, and what's really been hard in terms of the animal law practice is sometimes, economically it isn't always the best decision to make, but if for a principle of it and for advancing the law, it's something that you can kind of play your part as well. But unfortunately, to hire an attorney to go to do something civilly costs money, even on a contingency basis, which most attorneys take cases either, well, there's kind of three ways. There's a flat fee of, okay, we'll get you from beginning to end for X amount of dollars. A contingency basis, which is at the end, the attorney will recover a portion or percentage of whatever you recover, but the client is also responsible for costs of kind of getting there. So it's a little bit of a gamble for the attorney. And then the other way is on an hourly basis. And so for a lot of issues, a lot of the animal issues and newer issues, it's the only way that we can do it is really on an hourly basis, which can add up. But the animal law attorneys deal with a whole wide range. Pet trusts, somebody steals dogs, but any kind of harm that's done to you or your animal. But what's hard is we get a lot of phone calls too of somebody that's like, I know of somebody down the street whose cat was killed. What can I do? I feel bad about it. What can I do? And we can't do anything for that person who feels bad about it. It really has to be that person who is harmed. That sort of thing. Yeah, there are, in law libraries, they have some newsletters and things that are printed that kind of come down with decisions. And there are, FindLaw is a FINDLAW.com. It's kind of the two major legal databases that lawyers use are Westlaw and LexisNexis. And those are also, if you, as a private person, you can put in your credit card and pay $100 an hour or whatever to get that information. But FindLaw was established as an alternative to that for attorneys, but also it'd probably be a good resource as well. But it really depends too on if you want local or state, federal, administrative decisions. There's kind of different databases for kind of different levels. Yeah. It's a new, but just for animal organizations? Mm-hmm. I don't know a lot about New York law, and kind of that nonprofit, but there are, what's a kind of interesting development is kind of related to that is that there are some state statutes that allow for private prosecution of laws. So they've delegated that role to humane societies, or I'm sure in New York to the ASPCA, to be able to so it doesn't have to be a DA or from, they're specialized kind of private prosecutors. So I would imagine that, if it was a case of animal cruelty, you as an organization really wouldn't be able to sue, because it would really, normally it would be the DA or the DA's office that would do that. And so now it's been, I guess, regulated to the ASPCA that they're able to do that as well. So even if it wasn't in your bylaws or your articles of incorporation, my gut feeling, without knowing much about it, is that you wouldn't be able to prosecute the animal cruelty statute anyways. But if they're restricting you from bringing a civil lawsuit, that's kind of a different matter. That one's not. Because if it's something that is harm done to you or your members, that's kind of a different situation. Yeah. Well, the owners of the dogs. Well, yeah, they would certainly have a case to try to bring forward that their animals were killed and harmed. Is there a duty to make sure that the dog is dead? You could certainly argue it. It's interesting in animal law. There's not really a lot of cut and dry this is on this side and this is on this side. Lawyers, they can argue anything. So, but is there an obligation? I mean, it really depends on for the animal control, what their mandate is, and it's pretty specific. But yeah, I mean, if somebody wanted to bring an action saying that they didn't reasonably follow up and they didn't properly, I don't know about the disposal laws of in terms of dogs. There are a lot of different creative ways to pull some legal issues out of that scenario. Oregon. Work on it, but yeah, sometimes it's just there's some roadblocks there that hide. Yeah. ahead, Carter. Yeah, I can go into a little bit, but the next panel, Mindy Kurzban is doing an Animal Welfare Act 101, and she's going to go all, no, that's okay. No. So yeah, actually a lot of the topics I talked about will kind of be explored further, and there's some, yeah, attorneys working on this as well. Sure. Yeah. lemon laws also, I mean, it definitely goes towards just kind of the proliferation of too many companion animals and sounds like llamas as well. But also to try to help with the inbreeding, because obviously a lot of those genetic diseases come from animals that are inbred. But go with dogs. But that's yeah. Yeah. Okay, well, I'm glad you're all here for the weekend, and feel free to grab me for anything, coffee, tea, questions about animal law, and enjoy your weekend. And thank you.
Of cases you're interested in taking is really going to determine how you need to structure your practice. Or, depending upon how much money you've got to play with, you may need to look at financial considerations first, and then say, depending upon what financial considerations I need to make, will determine the types of cases that I'm able to take. For example, if you want to look at it first from a substantive point of view, you can say to yourself, what are the issues that move my heart the most? Do I want to be involved in dog fighting, animal abuse, cruelty issues, etc.? Do I want to really attack the issue of standing and try to be able to gain standing for animals through courts of law? You can look at it in terms of, what types of animals does my heart go out to the most? Do I want to help farm animals? Do I want to engage in wildlife issues, whatever? So you kind of take a look at what is it that you really want to do the most. And what I say to people, not necessarily even for practice in animal law, but as a general matter, when people say, well, how did you end up in this, or what should I do with myself for a living? I always find, you say to yourself, what would I do for free? And if you can figure out what it is you would do for free, if you can make money at it, that's just gravy. So, next thing that you need to consider if you're going to be in business is, how am I going to actually earn money at this? Here's where the two kinds of concepts you need to look at sort of mesh and will probably conflict for a lot of people. Animal law is a business just like any other sort of business, and you really do have to treat it that way. And if you want to take cases, for example, on an hourly rate basis, that's great. If you can actually find people who pay you money to do the kinds of things you want to do, that's fabulous. There's some upsides to this, and there are some downsides to this. If you find hourly rate work, or rather if you take hourly rate work, you're going to be more likely to be able to pay your monthly bills, which is cool. We all want to be able to pay our monthly bills. However, it is probably going to significantly limit the kinds of cases you're going to be able chances are the only people who are going to pay you to represent them are people who are involved in companion animal cases, because those are the people who view their animals as members of the family and would be more likely, if anything, to retain a lawyer for legal services on behalf of their companion animals, just like they might retain a veterinarian for medical services on behalf of their animals. So if you take hourly rate work, chances are you're never going to be involved in things like trying to force open the inner workings of an IACUC or animal research issues. Chances are you're not going to be able to work on farm animal issues, because the farmers, who are the ones who, if anybody, would have standing to bring a case regarding their animals, are the ones who are generally hurting the animals. So they're not going to be bringing lawsuits. I mean, if you happen to find a farmer who's engaged in some sort of turf war with another farmer, maybe. But by and large, looking at hourly rate work, you're probably going to be looking at only at companion animal issues. And you still may need to take other types of cases to supplement your income. There's no guarantee you can actually earn a full-time living at it. And my best suggestion is, if you want to try, you probably need to be in a major city so you have as many potential customers as possible to draw from as a base. And you want to set yourself up in a wealthy neighborhood, quite frankly, or some urban area with pockets of rich people who might be interested in spending money on these kinds of issues. Another possibility is to take contingency claims. Now, if you take cases that offer attorney fee provisions, it's going to widen up the amounts of cases, the types of cases that you take, but you're still going to probably need non-animal cases as a source of income. For example, what are some types of contingency fee cases? Well, most states have consumer fraud statutes. Most state consumer fraud statutes provide for recovery of attorney fees in the event of a successful outcome. So if you're looking, for example, at suing a breeder who is continually churning out defective animals, that's got a lot of issues bound up in it. One of the issues is probably going to be consumer fraud. Okay, so you can probably take a case like that if you're able to finance yourself in the meantime on a contingency fee basis, because if you're able to prove your case and recover, there would be the possibility of attorney fees. Now, of course, the upside is you can take a wider array of cases than just the hourly rate cases. And the downside is you have to be able to finance yourself in the meantime, which means you're going to have to take other work, which is probably not going to have anything to do with animals whatsoever. Or you need to have some other sort of income coming in some form or fashion to be able to support yourself, so you can make your monthly rent payments on your office, and you can pay your monthly phone bills, et cetera, until you're able to resolve the case and have that income come in. And even on a contingency basis, you need to keep in mind that there's still a lot of types of cases, depending upon how your state law is configured, that you're not going to be able to take when they only permit recovery on the basis of, attorney fees rather, on the basis of the total recovery. It's going to vary from state to state, but I practice in Illinois myself. I'll use Illinois as an example. That's what I'm most familiar with. Medical malpractice. You're allowed as an attorney, depending upon what stage in the proceedings you get to take roughly a third of the award. Now, that's fine if you're talking about a traumatic brain injury or a wrongful birth of a baby or something like that, where you can anticipate a very large recovery. So if you are in litigation for a year but ultimately need to recover $1 million, most plaintiff attorneys will take that risk. For an animal case, it's quite possible that you can litigate the case for a year or 2 years or more, even if you get a phenomenal recovery in a medical malpractice case. For veterinary malpractice, there was just an award in California. We can talk about that at $39,000, which, to the best of my knowledge, is the largest veterinary malpractice award ever. So you take a third of $39,000, you're still only talking about $17,000 or so. The case went on for several years. So as a practical business consideration, you cannot litigate something for 2 or 3 years and then recover $17,000. You'll be out of business. You're not helping yourself. You're not helping animals. You're not helping anybody. It's a harsh reality. Everybody would love to help animals. But if you're going to do it as a business, you need to actually keep in mind business considerations. Pro bono. Very popular with animal rights. Everybody loves to take cases pro bono. It's wonderful to do that. I take cases pro bono, but it's got to be a balanced portion of your caseload, because pro bono is exactly what it says it is. You're not making any money from it whatsoever, which means you must have income coming in from other sources. You take a job with a large firm. You may say, well, I hate this large firm job, but it pays the bills, et cetera, and I can take work on the side pro bono, which is great. In those instances, you can take any sort of case that moves you, no matter what other hurdles there might be. You're not charging the client. That's usually the key to the courtroom door. They'll come and sign with you, but then you need to make sure that you're able to support yourself in some other mechanism. And you need to keep in mind, too, if you take a job with a large firm, it still depends what the firm is. You know, you can take a job with some place and maybe make $40,000 or $50,000 a year and have roughly a 40, 50-hour work week. And then, yes, you might have time to do some pro bono. You're not getting paid a lot, but it'll be enough you can live. If you take a job with a firm where you're making the 100-plus salary a year, and the starting associate salaries now are up to major markets, somewhere around the 125 mark, those places expect you to work 70, 80, 90 hours a week. So if you're working 80 hours a week, if you can find time to take pro bono work plus your 80-hour work week schedule, God bless, and go to it, that can be very, very, very draining. There's not many people who give up 80-plus hour work week schedule plus cases on the side. There's other considerations that you need to take into account at that point as well. When you work for other people and you're taking other kinds of cases on the side, it has to fit in with your firm culture. You know, if your partner loves hunting, they're not going to want you working on some pro bono project to try to ban hunting in your neighborhood. Okay? You know, if your firm represents Tyson Foods, they're not going to want you picking up pro bono work for Farm Sanctuary or, you know, United Poultry Concerns. So you have a lot of considerations in that regard to take into account before you're able to do anything. So if your biggest goal in life is you really want to work on farming issues, you can't, for example, go work for a firm that represents agribusiness. The upside, though, of taking pro bono cases is that you really can take any case that moves your heart. Anything, any sort of case, including types of cases that clients might normally pay for. For example, if somebody wanted you to set up a pet trust for their pet animals, you can take that pro bono if you want. But you want to keep in mind, too, you're running a business. And is there really a value to doing for free something that somebody would otherwise pay for? The types of examples I've got set up on the screen are sorts of things that clients normally pay for, and you want to keep those kinds of things in mind as a business consideration before you're free to go do whatever for anybody for no money whatsoever. Any nonprofit on the planet would love to have their have themselves incorporated and have them registered with the IRS for tax-exempt status for free, not just animal issues. Any nonprofit for any type of issue whatsoever would love to get help for free. The fact of the matter is, if they don't get free help, they will pay for it. And harsh as it sounds, let them pay for it. You know, I think that part of the problem in getting society in general to accept this as a serious movement, a serious social issue, is that for so many years, everything has been completely underfunded, unfunded, and it's like a badge of honor to poverty-stricken. Part of what I personally believe is going to propel this movement into the 21st century mainstream is that everybody's got to realize that this functions just like anything else. It runs on money. And you shouldn't be afraid to value your services and get paid for your services. Not to say not to do any pro bono, whatever. I do plenty of pro bono too. There's always going to be a soft spot in your heart for some whatever it is that comes along. As a general matter, don't feel afraid to say, this is my time and it's valuable. If you want my professional advice, it's something that you should pay for. Okay. Now, before you take any kind of case, and I realize there's some people in here that are practicing attorneys, and this is going to be old hat, and there's some people who are going to be considering what to do with themselves for the rest of their careers, and so hopefully this won't be old hat for everybody in the room. You've got to really consider the merits of the case. Okay? Look at the claim, first of all. If it's an animal, if it's related to an animal and you really want to get involved in animal law, you need to kind of look at and say to yourself, is this really an animal law claim, or is it just a claim that happens to involve an animal in it? It may, for example, really be an American with Disabilities Act claim. The guy gets turned down, somebody, service dog is not allowed into a public accommodation. Is it really animal law? Well, it's got an animal in it. It's really an ADA claim. You still get involved if you want to, but it may not, before you look into it, be the kind of case that you think you're taking on just because it involves an animal. you have to look at the clients. What are the client's goals? Okay? If a client comes in with a really tragic story about something that happened to their pet and their goal is to get $1 million, we're not going to be able to help this person because no matter how horrific it is, nobody anywhere in any jurisdiction in the U.S. is getting $1 million for anything. You're not going to be able to help this person. Likewise, if the client's goal is to be purely vindictive against the tortfeasor, that's not a legitimate purpose of the civil justice system, and be careful about that as well. So you want to do your client screening just as carefully for this as for any other area of law, and you don't want to take cases where 6 months down the road you're going to be wringing your hands saying, oh my God, what did I do? You may also want to look at what side you're on. One benefit, for example, of being in private practice is you can decide what cases you want to take and what cases you want to turn down. I know me personally, somebody will call me their dog has bitten someone. Maybe I'll take the case and maybe I won't. It depends. First of all, I don't represent dog fighters, drug dealers. I do get those phone calls. You know what? Those are hard cases to turn down because those people are willing to pay. And if they don't get their services from me, they're going to go to some other criminal defense attorney. And you know what? Criminal defense attorneys in Chicago, maybe you can get somebody for $250 an hour. Maybe it's like $300 an hour. It's a lot of money to turn down, but I find those cases personally repugnant, so I won't take dog fighting cases. Now, on the other hand, you know, some numbnut accidentally leaves his fence open, the dog gets out, bites somebody, and the local warden wants to put the dog down because it got out and bit some other dog or another person. That I'd be more inclined to take. It's not really the dog's fault, it's the stupid owner's fault. So you need to take a look at what side you're on. Maybe I want this case, maybe I don't. Again, it's a lot of weighing back and forth because quite frankly, the cases where you're likely to make the most money with dog fighting, drug dealing, that kind of thing, it's a personal decision. And the truth of the matter is, everybody's entitled to a lawyer. So you could decide to make a different decision than what I made, and that's fine too. If you take away nothing else from this talk today, what I would like everybody to remember is that animal law is a business like any other area of law. And I've been to a whole bunch of these conferences, and people talk about all sorts of horrible issues with animals, and yes, it's all very tragic. And the one thing that nobody ever really talks about is that this is still a business. Treat it like a business. If you don't treat your business like a business, you will go out of business. It may sound harsh, but that's the way the entire rest of the world works. And if you want to get in there and be competitive, if you want to go toe-to-toe with all the insurance companies that are defending the doctors that commit medical malpractice, with all the insurance companies that represent all the other assorted tortfeasors out there, with all of the agribusinesses that are committing horrible practices, you need to bring the same sorts of skills and resources to bear as any other corporate lawyer or litigation attorney in any major firm in this country. You don't do it by being touchy-feely. Be touchy-feely on your own at home when nobody's looking. But when you come to work and you go to court, you've got to be prepared. It's a business. You've got to evaluate every case you take from a business perspective. And if you really decide every once in a while to take something because it really moves your heart, that's okay. And I'm not saying to never ever do that, but you have to be really cognizant that that's what you're doing. Okay, well, I've covered a bunch of this already. You have to be a good business person because if you don't stay in business, you're not able to help anybody. Do all the same sorts of things that anybody in any other sort of business would do. You need to set up a professional shop, okay? If people are going to hire you as a lawyer, they don't really want to see you walking around in jeans and having client meetings sitting in your backyard. Set up a professional shop. You need to walk the walk, talk the talk, look like any other attorney. Invest in marketing, advertising, website, join professional associations. Develop business relationships with other attorneys. They need to know you're out there. They need to know you're serious. So, you know, when somebody calls you for a DUI, well, maybe you refer that to the criminal defense lawyer down the street, and when somebody calls him because, you know, their cat died at the vet's office, this guy needs to know to have that person call you. As with any other business, you need to evaluate these claims carefully. There's lots of tragic things that happen to animals all the time, but you know what? Lots of tragic things happen to people all the time, too. You can't take a case simply because it's a sad story, okay? If there's something seriously flawed from a legal perspective, if it's past all of the applicable statutes of limitations, if for some reason you are not going to be able to prove an element of a claim, you have to be able to look the person in the eye and say, I am really sorry this happened to you, but I'm not going to be able to represent you. I work in a suite with other attorneys, and there's a guy next door to me that does medical malpractice, and I hear him say that to his clients all the time. Sorry this happened, but I'm not going to be able to help you. Yes, you know, an animal got hurt, it was tragic, whatever, but just like with people cases, you have to know the limitations. You have to screen your clients carefully. You're going to be taking hourly rate work. You expect to get paid up front. It's a business relationship. Get paid, send regular bills, expect regular payments. Do the same sort of client screening you would do for any other type of case. If a client comes in and their story doesn't add up, they're not answering your questions, if you're being a problem for whatever reason, go with your gut and turn the case down. There will be somebody else in your office next week who's also going to have some sort of problem, and you want to allocate your resources wisely and apply them where you think you genuinely need to do the most good. Final business thought. If you are the sort of person that absolutely, unconditionally has to help every single animal that comes through, don't practice law. There's lots of things you can do to help in this movement. There's all kinds of advocacy groups you can work with. Law does not provide a remedy for every single wrong. You need to keep that in mind. It's very frustrating. But just like with people cases, the law doesn't provide a remedy. You have to be able to say, as a business decision, I'm very sorry that this happened. I'm not going to be able to take this. Okay. Enough talk about being in business. So you're in business, and whether you're set up as a solo practitioner or maybe a small practice with one or two other people, focus on animal rights or animal law issues, or even if you're working for some other organization and the majority of your practice constitutes something else and you just simply want to take cases on the side, what types of cases can you take? And I'll run through briefly some of the substantive areas that I'm familiar with, which is mainly companion animal issues. And then Adam's going to talk about some of the areas he's familiar with. As most people probably know, the very biggest hurdles in taking any sort of case involving companion animals involves standing, and it involves non-economic damages. Those two topics could in and of themselves be entire hour-long sessions of discussion, but those are obviously two issues to keep in mind. When someone walks into your office, am I going to be able to bring a case for them? Well, if it's a pet owner regarding their pet, the answer is pretty straightforward, yes. If it's not, then you've got a lot of other issues, and Adam's going to be talking about that in a little bit. What do you do if you don't have a clear-cut method into court or clear-cut plaintiff to get yourself into court? The issue of non-economic damages is another really cutting-edge issue in law. So you need to take a look at something. For example, most of the cases I take, I rarely take a case where the animal is still alive. It sounds really harsh. The fact of the matter is, for any sort of non-economic damage argument you're going to make, it's a much, much, much more difficult argument if the animal's not dead. Illinois, for example, there is a case that came down from the appellate court that encompasses the area where Chicago was located just this past year that said loss of companionship is not allowed in non-fatally injured cases involving children, human children. So clearly, they're not going to allow loss of companionship for a non-fatally injured child. They're not going to allow loss of companionship as an element of damages for a non-fatally injured animal. Again, it might be a horrible situation, but you need to evaluate from a business perspective, am I going to be able to do something for this person? And you need to have that conversation with the client right up front. And I will tell people, you know, on the one hand, the fact that your pet hasn't died, good, because you still have this, you know, companion around as a friend. I said, on the other hand, this is not good for your case. Now, of course, I have a lot of clients where the animal is dead, and they would switch places with you in a heartbeat. So it's good news and not good news. You just be right up front and explain about damage issues, and if they want to proceed, make them proceed, and on a fully informed basis. Veterinary malpractice. If you look at areas of substantive law, tort law, a lot of my caseload involves veterinary malpractice. I choose to treat it like a medical malpractice action rather than a property damage action, because under Illinois law, you're going to have greater avenues to recovery, at least theoretically. But of course, then you have to go the full route and treat it like a medical malpractice action. In my state, for example, the statutory requirement that you have to have an expert prior to filing. So I have a veterinary expert that will review records and give an opinion, has to write a formal report before I sign off and file on anything. You need to know what the elements for your state are. Every state is going to be different. You need to check for statutory hurdles like having an expert report. One really good new case to draw to everybody's attention is this Bluestone case in California with a $39,000 award. Again, to the best of my knowledge, that's the highest veterinary malpractice award so far in the U.S. There's all kinds of cases involving emotional harms, or I should say there's several causes of action which can encompass a whole range of circumstances, intentional and negligent infliction of emotional distress. You need to know the elements for your state, and in a lot of states, particularly negligent infliction is going to be very, very high hurdle to meet, because a lot of states have contemporaneous injury requirements, zone of danger requirements, so you need to know what's out there, and then you need to be able to make arguments why you can overcome those hurdles. There have been several instances where there have been fairly substantial awards for emotional harm, and I've got them listed here on the screen and in the handout, and that might be useful to saying to a judge, look, these kinds of cases are being taken seriously, and there's some instances where substantial awards were made. Of course, the more closely you can analogize to any of those fact patterns, the better off you are. I find as a general matter, courts are more willing to accept the proposition that an individual person do some egregious thing, less willing to adopt a mindset to acknowledge that maybe a veterinarian could do something egregious. So far, I think what we've seen is there's more likely, if anything, to be larger awards for individual tortfeasors. Negligent infliction, there's really very little good case law out there, and if you can't find a good new case, then you have to go back to something, as it were, and Campbell versus Quarantine, which I imagine most of you guys are familiar with, is still probably the best case out there for negligent infliction. What you need to do in instances where you don't have good new case law to rely on is you can say to the court, look, this came out more than 20 years ago, and it didn't open up the rate of terribles. You don't get negligent infliction for property loss claims all over the U.S., and there's no reason not to allow it here if your only concern is that it's going to open up the floodgates. There's other types of negligence actions you can bring. It will be largely determined dependent upon what your state's laws provide. For example, in Illinois, we now have a civil provision in the state's anti-poaching statute. So an individual can sue another individual for alleged wrongdoing to their companion animal, regardless of whether or not the state brings a criminal prosecution. Not every state has that. In fact, most states don't. But once you get familiar with each of your own individual states' laws, there may be specific causes of action in there. And God willing, they'll have statutory provisions for attorney fees and maybe punitive damages. And you can use those as vehicles for bringing suits. I also do some condominium and zoning types of issues. For example, somebody lives with a dog for 10 years and the condo board changes and the board says your dog has to go. Well, what do? Well, the first thing you need to do is read the client's condominium documents, see what's in there, see if there's really a prohibition in it, see if you can make grandfather arguments that the dog's been there long enough, see if there's other waiver arguments you can make. If there's been a recent change to bylaws, you've got to get in there and read exactly what is in those documents and find out, did the board follow its own policies and procedures in enacting the rule change? If it didn't, then you attack it from this as not validly enacted. Of course, even if you succeed in getting it struck down, they will likely just go and reenact the provision in a valid manner, but it buys some time, and they may ultimately back down if it turns out that enough of the unit owners in the building are objecting to the change in policy. There is actually a fairly good, and I'll also check to see, depending upon what the specific fact pattern is, it's it's a claim having to do with a person who has a therapy dog, for example, may have a lot of other claims bound up in there. So don't forget to check for things like ADA claims or Fair Housing Act claims, which can be pretty powerful tools. Do provide for things like a recovery and attorneys. I've got one good case listed here from California, which if you're doing a condominium law case, you may want to read this as well, just to get some ideas of types of arguments you can make to defeat condo boards saying we've got unilateral discretion to do whatever we want to do and we say no pets. Zoning, same types of things. You need to read the ordinance. I had a case at one point where the client got a threatening letter from the local town. She had about 8 cats, and you're in violation of the ordinance. Well, I read the ordinance. You know what? There was no pet limit on the ordinance. So I wrote a letter back to the town supervisor, whoever the municipal attorney. I'm like, I'm reading the ordinance. There's no limit. What are you talking about? So his next move was to write me a letter back. We've decided she's a pet shop. She's in violation. She doesn't have a license. She has more than 2 animals, and she's not licensed. So I wrote him a letter back. And I'm like, this is a woman who's been living in this private residential neighborhood for in excess of 30 years, paying property taxes on her single-family home. If you don't cease and desist, I'm going to seek a declaratory judgment asking the court to determine that my client is not a pet shop. Stupid, but they back down. So know what's in your ordinance. And even if the ordinance does provide for some sort of limitation, then the argument becomes, well, what is the limitation? Does it apply to my client? I mean, if your client's got a pot-bellied pig, it's been an ordinance in effect since the 1800s, no pot-bellied pigs, it's a losing argument. You got to tell the client you can fight for a change, okay, but you're probably better off going through such as legislative process in those types of instances. You may be able to make analogies to cases where this case in Illinois, it was a pet monkey. Technically, pet monkeys weren't allowed, but they made analogies. It was really like a pet dog or cat because it's lived since birth, et cetera, et cetera. Look for creative arguments. Contract law. Again, I could go on in great and gruesome detail here, but contract law is useful for things, for disputes involving puppy mills, breeders, kennels, bailment situations. Recoveries can be sort of limited, so what you want to take a look for is if there's any way you can allege fraud in any of these situations that gets you into the whole tort arena and, ta-da, gets you into consumer law. That's a really powerful tool. If you can ever find a way to take any contract-related claim and make a good faith argument sounding in tort and bring it into the contract or the consumer fraud arena, do it, because those are powerful tools. Some other areas of law that I am not terribly involved in, but if you are interested in, I can just give you some resources so you can learn more about it. Pet custody is becoming a very hot issue, and petcustody.com has some good resources to get you started. I have dabbled very briefly in divorce law, but nothing to do with animals, so I can't talk too specifically about that. Animals are considered property under the law. Most judges really only look at that as a division of assets, and the goal is to try to get them to look at it in terms of best interests of the dog. Estate planning. More than half the states in the U.S. now have forcible provisions for pet trusts, which means that it is no longer okay to simply give your money to somebody in hopes they take care of your dog, and that person could actually go take the dog to the pound for euthanasia and take the money on vacation. Forcible trust means your wishes can be honored after you go, and so that might be type of practice area where eventually everybody's going to die. Hopefully everybody makes plans for themselves before they go. There's a lot of resources out there now for estate planning for pets, and this is one website that's got a good comprehensive list. It's a good place to start. So that is the presentation, and I will turn it over to Adam now, who will talk about other sorts of causes of involvement. Thank you.
Hopefully you can bear with me while I get set up here. Hybrid contingency is another way that you can rely on your contingency. Another way to do it is to ask your client to pay a flat rate, plus a percentage for free filing. And if you have to actually turn on a file suit, you can ask for another sort of fixed non-refundable installment. That should up your 10% at the deal. That at least will give you a little hope. Another option is seeking grants. A lot of us can't fund costs, and so know that. And they'll try to vary you with acquisition costs. They'll put everyone in sight, and you're going to spend by your cost. Court reporters, bless them, my wife's a court reporter, but I'll tell you, so what I do is beg from great organization. They have a projects and litigation committee, and you can, every month, they will entertain proposals for $200, $1,000, whatever. Funded. I don't know if there are other organizations that do that, but in Washington County, civil rights projects, market expansion line. Now, like Amy's in a big city. She's in Chicago. I was in Seattle, Bellingham, small city, right up the border. But because there's so few of us who make a lot of communication, frankly, if you're going to do animal law, you're going to have to grab that in, hold on to this tight. You're going to have to expand your practice beyond the geographic. They have to push into other big cities statewide. Do that, consider a market expansion law. Each month they'll be able to call them local. So then they'll think you're there, but you're not there. Local area codes, they will then ship right up to your office. Again, associate with local and split fees so that you can still have a presence. Another real factor on the flip end is instead of putting money out make sure that the litigation progresses, there's also the risk of you putting on money to the other side or to the court or sanctions. And, increasingly, I don't know if this is saying something about how I practice, but increasingly a number of lawyers are pushing through CR11. And I think that uniquely as animal law attorneys, we need to be very mindful of the risk of sanctions, especially in the climate where judges, public, they can have some sort of a think that what we're doing is absolute. We're asking for far too much backlash, even though it's undeserved reality. So be mindful of CR11. Again, that comes apart in evaluating the case. The heart may be in it, but if it is truly based, take it. There are also some statutes here in Washington says that if the whole action itself is frivolous, it advances power. But really, it's that. There are malicious prosecution statutes that also. There's also the issue of ethics and how you teach. For me, there are a couple of things that are strong concerns about getting them. I have clients whose animals might be spayed. Question is, are you going to invest lost property, lost project, lost study? Yeah. Appropriate ethically lost profits on it. Clients certainly deserve that the law may support it, but ethically we can't help it. It's just a consideration. Same thing with the Humane Society. I've done. They support them, they may be very good. The animal community isn't just with them. It's also with Humane Society, shelters, and breeders, and every other animal care. So when you take action against it, it's going to impact you. Finally, pro bono work is the only really just price it down, $30 an hour, $50 an hour. But if it's guaranteed money, at least you're having some flow, showing some respect. Okay, so lot of this is already in my material, so I'm just going to call your attention. Applied cause of action. In Washington State, we got our felony out. Auto was killed. As a result of that, 2 years later, in 1994, Washington State legislature passed it hasn't changed at all, but it did change. Actually, had sense of second and third set on fire at a middle school. Dr. died. Changes to, I think it was Senator McCaskill. So upset that the juvenile, 17 of them, received just a minor sentence. And sentencing. And the changes are significant. It ranked up the severity level. C to D, that's the same type of sentencing. It also made it so that even if they leave a deferral disposition, conviction is not expected. So in Washington, these are some of the changes. But what I did, I took a civil case. I recommend it because, on the one hand, as you know, there's going to be lateral estoppel effect. So if you can prove, if the prosecutor can prove the elements of a crime of animal abuse without slip it. Well, and I ended up suing parents for a variety of statutory debt. One approach is I had my protection. In Washington State, we do something like that. And then it really borrows from the federal test. The federal test is particular. Really free. You've got to show, you're going to try to apply a cause of action, statute. Show more or less what the legislature intended implicitly or implicitly, and that if you provide civil remedy or provide, it has to be consistent. This is how it is in most other states. So, I'm going to try to build a bridge between an implied cause of between an existing statute and a new implied cause of action. Like a criminal and civil code, and I'd argue common. Criminally, cruelty to animals. Obviously, that's what we're trying to create a civil right of action concerning animals. In particular, focus on the factors that maybe the legislature wants to see indicate that there could be here. There are forfeiture of animals is the defendant isn't having animals. Unfair expenses. These may not want to be better. Stay in the line of after enduring mental cruelty, would be sort of slipped in as part of restitution. Washington. In addition, if you are convicted, $1,000 penalty on top of it. Fungibility is defined going to be why are those important? Well, often they will use the tool. We'll talk about companionship. What is a pet? What is a pet animal? How's it different from a farm animal, a work animal, a service animal? Statutes, what they do, there's a shift in our mentality, a shift in actually, as I'd say, even hermeneutic in how you view this animal. Problem. On one hand, it's not like it does. recognize by the statute. Moreover, there's a pain and suffering framework of culpability that only applies to sentient animals. It doesn't apply to any other property because they can't. What does this mean? That the law and the implication would be two of them. One, the sensate nature of the property recognized by the statute. It's arguable that there's an implied civil right that is enforceable. Anything for civil property. And how are the laws keeping animals property different from civil code? Some states say animals without water, right? A trespass provides sustenance to the animal without being charged civilly for that trespass. And that goes to show that there's a consideration of the animal's rights or interests above any property. Also, law officers in Washington, they can actually remove an animal immediate trusts, another area to look at. Washington State actually allow unrelated petition trustee in the best interest of the beneficiary animals that are not being met. Radical. Again, I think that goes to show again what it is. Service animal injury, civil cause of action. In Washington State, your state may have to you can get attorney's fees, $1,000 penalty, and damages. Also, criminally, discuss value that's to be in the event that a service animal is killed. Say, intrinsic value. Washington State, there's also a civil cause of action. Livestock. This is what's kind of Washington sort of, I think it came out of a lot of relation. Yes, it was and horse rustling. So this is where the did come. Not the Washington have there's a slaughter, but not for them. Again, I'd argue that the status of the law now is going to recognize the right to farm. Other laws another. That's the Animal Act. Now, Washington State, there's a that tend to stand for the proposition that if an animal is injured by a veterinarian, half the original value of the animal. However, if the animal does die, because you tried to mitigate, you get the vet bill presumably up to the original value, plus the original. Well, the original value isn't defined. There was a horse that was hit by a car, and the horse was reported in 1980. But that might provide a limitation. However, under the cruelty law, you can prosecute without providing necessary veterinary care. And that shows that there's a degree of care owed to the animal, irrespective of owner. Even subjects the owner. That's allowed. Even the classes I did see in one court case that they applied that to the case of a dog that was harmed. Instruction on death provision. Many courts say that those are invalid as a matter of law. When I die, that's my animal. When I die, send my car wrecking it. Most courts are going to say it's against public policy. In that sense, that tends to reflect perspective that there should be waste without profit. Best interest of the animal standard, law. I cited a few cases that actually employ it. Public trust doctrine, I got this from an attorney, Dale Trump, California. And, she recently took the case involving the elephant. She successfully argued the public trust doctrine. Normally only applies to African waters, but she was able to get it extended to what does that show? Again, it's showing an implication that the best interest of the animal is considered should be a civil right protected. Similarly, property rights are suspended in lieu of supporting the animal that should also support the civil right. You can analogize or you can improvise on it. Analogies are pretty hard. You can stare down and accuse all sorts of things. You try to say that a wrongful death statute only applies to human children, apply to So what I always am carefully do is say, I'm not arguing that the companion animal is a person intended by the legislature, but that is a good analogy. Same thing with pre-death payment. Another option is the next topic is how do you combat racism? Ways of combating the arts. Getting the media involved, sending and educating on number one. Safely, that second and surviving on our death. The office the evidence destroyed. That's I think the major reason why. You can also try to recommend that allow an individual force the government designated official to take action as required. You can't force or compel a government agent to perform a discretionary. Suppose you could say, you must exercise your discretion. That's not a It's quite different than forcing them to do something that's necessary. With prosecution, as you know, prosecutors have to provide discretion. You don't have to charge them. Take a look at the state versus Kurzban. Here we're versus Kansas. Where the mother received a son shot after the VA, and it was not done. And so it went up on appeal, and ultimately it said that the decision by the prosecutor was truly subjective, exercising discretion. It at least articulates how might be able to statute. And then I just read get it? It's the article by Maru Shimakamari. It's on taxpayer standing, except step toward page 265. The author discusses a case in Ohio where, concerned by the method of euthanization under an Ohio statute, not using subject to harmful cause, this individual filed a taxpayer suit to the county commissioner to stop the use of carbon dioxide. That's another way to do it. You can't get the carbon dioxide. Declaration, method of euthanasia violates the program. Okay, animal control officers also make their own independent power to enforce your program. Take a look at the chapter. You may not need a prosecutor. The ACO yourself, the Humane Society office, may be able to file without any. Pause versus Culp case is Exhibit D. This was in Washington State. PAWS is the Progressive Animal Welfare Society in Linwood. At the time, Mitchell Fox, who was one of the founders, Mitchell Fox worked with John Costin recently to file a criminal charge against an individual, Jack Miller. You know about it occurs every year up in Sullivan County, central part of Washington State. And what they do is they run horses down a massive, very steep grade. They call it suicide. Now, that doesn't mean riders aren't going to get gymnastics. So there was an effort here to have a exception by the defendants. Well, Mitchell Fox, being a peace officer or being a society officer, had authority to file a bid. It was now out. It was unfiled. It was actually unfiled. The judges, the district court judges there, talked openly about the case, expressed their views on the case, and then proceeded to white it out and send it back. So there was a writ of mandamus that was sought saying you've got to accept it. You have to issue the summons to Mr. Miller. You can't go about conducting your court in this fashion. Well, as a result, the judges filed a writ of mandamus, essentially arguing that the entity that was the petition is acting outside of the same cause that was outside of the charter. Went up to the Supreme Court, back since that case, Sato's law came down, everything was amended, and now I believe the right of an animal control officer to enter into the file is not your statement. Another thing is look at the blue one. This one blew me out of the water. In Washington State, there's a citizen provision issued by property prosecute misdemeanor crime. It's recommended if you're going to do it, standards are, with the statute that you can codify, to be able to argue pro compliance. Make sure you got at least public. Make it work wisely. And only from other misdemeanor crimes. Animal slaughter. Federal government, federal humane slaughter, I guess, no stop the law. In our state, it is a misdemeanor if they kill an animal. You might be able to prosecute. Well, you won't prosecute the case. You will petition to prosecute. Not to the prosecutor, but at least with New Jersey has a private prosecutor statute. You can actually petition the prosecutor to take the case, and if they formally decline, they may give you Missouri shareholder. They may have that. Like I cited to Amy Okuzinski, she gave a talk years ago about just such a case. What I want to do is at least get to the video. Police shooting dog cases. Some of them were highly publicized. Having smoke outside, televised, see highway patrol, shotguns on a dog, outside of an interstate. That case has been filed. The outcome. Amy Brown, this was out of Pennsylvania, people cite for the body. Federal case that's recognized as animals. And in this case, Amy was shot by an officer. The crux of it was that before he shot her 5 times, her guardian was apparently screaming at the top of her lungs, not too far away, through an open window, scream, don't shoot, she won't hurt you. Apparently paused, heard it, proceeded to kill her. Most of the shots entering her as she was running away. The court did find that there was a seizure, and you're going to, and now it is clearly established law. Anytime there's a shooting in the law, there is a seizure. reasonable, constitutional violation. Qualified immunity, the reasonable analysis, they're all pretty similar. But in any case, highlighted, there was a seizure. Fuller, this is the Washington, this is the Ninth Circuit case that you need to know. Fuller versus Vines, a 94 case, attempted shot on property Fuller. Actually, after he was shot, the officer then wrestled his son, Brown, or not the officer, his friend wrestled his son, after further confrontation, the officer said, needless to say, that resulted in a Now, I want to show you a clip. If you don't want to watch it. A minute long. This is the real case. I want you to determine whether this is a seizure. The argument was that the dog was charging there. But I want to sequence. Tennessee versus Garner, that's our Supreme Court case that says when you don't basically seize an unarmed, non-dangerous that is a dog unarmed. What type of they often say, oh, tasers don't work, mace doesn't work. There's a document that if you use that before you try, that means you don't. Canine, Ninth Circuit again, Miller versus Clark case. Miller versus Clark. The dog had held onto a man's arm almost down to the bone for 60 seconds. He was not using the use of deadly force. A matter of law in the Ninth Circuit, these dogs are never deadly force. Actual these dogs are never deadly force. Should not be. The real crux here is whether the rigor of the analysis is as strong as I'm trying to make it. I haven't found cases of the other one. Separated. We thought it was the same person. Children. That had all affected the support of one given or determined. State. Any questions in dog shooting? All right. So the piece that you saw here was things that we'd all wanted. You only saw a short. Actually, same thing. This pair of bark marks walk up and pull the the officer deems charging. Okay? One hand came out of nowhere and I had to shoot. Officer dance. He had it. Yeah, good point. Good point. Called when he called me. Two though. Apparently this dog down the street aggressively barked. Called at the scene based on that and his belief that this dog allegedly standard here is subjective is subject to federal law. Sort of a good dog. Another thing, the owner, in the Brown case, that's what happened. Mother there screaming, dog. We have a case where you're going to like in channel, yelling at the office, trying to get the dog on those that might be. Here, there was in any event, these are all critical factors.
Adam, who shot that video? Police officer, who was shooting the video?
This is more of a comment than anything else. One of the projects I'm working on in Eugene right now is we're challenging 164.887, which is interfering with agricultural operations. So I've done a lot of legislative research on it because we're wanting to overturn it, but ironically, you discovered that there's a possible pro-animal situation there, which is that one of the major rationales for passing this law was to they were arguing that there was a difficulty in assessing harm to the animals that were being harassed, so that vandalism law didn't work, trespassing law didn't work, and so they went ahead and passed this, which has got this interfering, hindering, obstructing. So there was really a lot of discussion about non-tangible harm to animals and how that there needed to be another law addressing that because it wasn't evident as it would be if you were hurting property. So they were really talking about somewhere between a person and a property, this whole area in between. So it's one possible basis for arguing that.
My question was, do you find that there are certain civil cases that you bring that have a greater impact on legislation